Perfect. All right, so good morning, everyone. My name is Michelle Adams-Gamula, and I'm an attorney at the law offices of Hoyt and Bryan. And so today I'm going to be talking to you about what you need to know if you're selling a piece of property in an estate, whether it's probate or in a trust. There are different rules and timelines that realtors, title companies, and their clients really need to be aware of if we have property that is titled in an estate. So here's a picture of us. There are 4 attorneys here at the law offices of Hoyt and Bryan, and we are estate planning and elder law attorneys. We have been helping families in the Oviedo area since 1999, and we do help families on a statewide basis in our estate capacity. So as Florida probate professionals. So we can help you sell property in an estate anywhere in the state of Florida. And I kind of put an asterisk on that, and it really should say anywhere except Miami or Broward, because they have completely different rules down there that sometimes are better suited for an attorney that just services the Miami or Broward area, because that's kind of like a whole different state.
Is that like Dade County and Broward then, pretty much?
Yes.
Both counties?
Yeah, Miami-Dade and Broward.
Okay.
So just the 2, other than the Keys, the 2 southernmost counties, they just do things very, very differently than pretty much every other county in the state of Florida. But we can help on a statewide basis. Meeting with clients, we do have 2 offices. Our main office is here in Oviedo, but we do have a satellite office in Altamont Springs at One Senior Place. And so we do workshops there on a monthly basis. They've got a really nice auditorium that can seat about 100. So that's really a nice opportunity to kind of reach different folks that don't want to travel from Altamont to Oviedo. So why is it important to determine how a property is titled? If you're selling a piece of property while someone's alive, the process is very streamlined, right? You're dealing with the person that has authority to sell the property. And that's the process that you're probably the most familiar with as a realtor, because the majority of your clients are people trying to sell their own houses. But when someone has passed away, we have a different set of rules and circumstances that we have to follow, because the person that owns the property is no longer here to sell it. So if you encounter a property where someone has passed away, these are the first things you need to be asking the client. And you need to try and get this information up front, because it's going to help the closing process run a lot smoother. So you want to know, was there a will? Was there a trust? There's going to be 3 sets of different rules. There's 1 set of rules for no will or trust. That means they died without an estate plan. They died intestate. Or there's a different set of rules if they had a will. That means the property's going through probate potentially. And then there's a 3rd set of rules for if that person had a revocable living trust and the property was titled in the trust. So it's really important for you to identify which of those 3 paths you're going down. And we're going to talk more about all 3 of those paths: no will, a will, and a trust. The next question you need to ask is, how is the property titled? This is important because the person might have a will, they might have a trust, but if the property is not owned consistent with that document is not going to control. So we need to understand what a will controls and what a trust controls. So a will controls assets that someone owned in their individual name that did not have a beneficiary designation on it. So property is titled in Dad's name and Dad passed away. That asset is going into Dad's probate estate because there's no one else on the deed with Dad that's alive. So we need the probate process in order to help us transfer title to that property. So probate means we're looking at a will or no will. What about a trust? A trust is kind of like a box. It's got a set of rules for what happens with the assets, but it only controls what is inside the box. So if someone has a trust, you've got to look at the deed and see if the property is titled in the name of the trust. If it is, the trust is going to be able to sell that property and the proceeds are going to be issued to the trust. We're going to spend most of our time today talking about wills and no wills because it's about how to sell property and probate. But I want to take just a minute to make a note about revocable living trusts. When someone passes away and property is titled in a trust, there may not need to be a probate, but there does need to be a trust administration. So trusts are great, but they're not a magic box. When someone dies with a trust, there is work that needs to be done. That trust needs to be administered just like their will needs to be administered. And so I had people that called me up and they said, we're trying to sell a piece of property that's in mom's trust. Mom died and the closing's in 4 days. Can you help us review the closing paperwork? And so I said, yes, of course, I can help you review the closing paperwork. The property was titled in the trust. There shouldn't be any issues. Daughter was the trustee. There's no issue whatsoever from a title perspective. The daughter could sign the contract. The daughter can sign all the closing paperwork as trustee of the trust. But when I started to ask her questions about the trust administration, I realized nothing had been done. So trusts need to be administered just like wills do. And that means when someone passes away with a trust, we've got to apply for a tax identification number. We can't use mom or dad's social anymore. They've passed away. So we've got to get a new taxpayer ID number. They need that for the closing paperwork to prepare the tax forms for the house closing. And there needs to be a bank account opened in the name of the trust to receive the proceeds from the sale. Those things take time. It takes time to apply for a tax ID number. It takes time to get the trust paperwork done and to get a bank account opened. And this person just had no idea that anything needed to be done because they thought that since they avoided probate, that everything was just going to be quick and easy. And it just wasn't the case. We were not able to get it all done in the 4 days that was the original closing date. Closing had to be pushed back because there was work that needed to be done for the trust so that we could receive the proceeds from the sale. So just a note, if property is titled in the trust, make sure they've got a bank account open in the name of the trust. Make sure there's somewhere that we can put the proceeds, especially if we're wiring the funds. The closing agent needs to have that information. So that's all I'm going to talk about trusts. We can talk more about trusts if you have specific questions later on. But the rest of the time, we're going to be talking about what specific requirements you need to sell property in a probate estate. So will or no will.
Hey,
The
Michelle.
third question you need, yes.
Sorry, real quick, just before we move on, with the tax ID number for the trust and the bank account opened in the name of the trust, are those things that can be done when the person is still alive, or does that have to happen after they die?
Yeah, it has to happen. You can open a bank account in the name of the trust while the person is alive, but you can't apply for the tax ID until the trust becomes irrevocable, which doesn't happen until death.
Okay,
so
thank you.
Yep. All right. And then the third question you need to ask, if there's a will or even if there's no estate plan at all, has an estate been opened? And that's going to be important as we go through what steps are involved in the probate process. If an estate has not yet been opened, you might want to encourage your client to talk to an estate administration attorney, estate planning attorney, about getting an estate open because the probate process takes time to move through. And the last thing we want is we don't want someone signing a contract to sell this house if we don't have authority to actually get that house to closing, because that just frustrates everyone involved, right? It frustrates the seller, it frustrates the buyer. We want to make sure that we've got all the pieces in place so that we can move through the process as efficiently as possible. So before you list property that is titled in someone's individual name, you want to make sure that an estate has been opened, or at the very least is in the process of being open. Right now, courts are backed up. Everything is taking a little bit longer than we expect it to take. And so what used to take a week or two is taking 2 to 4 weeks for a judge to review the paperwork, open an estate, and issue letters of administration, which is what your client is going to need to be able to sign a contract on behalf of an estate property. Okay, so you need the probate estate to be opened so that your client has authority to sign that contract. They don't have authority until the probate court gives them that authority. And that's really, really important to understand, because if property is titled in dad's name and dad's son is named the personal representative in dad's will, dad's son can't sign that contract until the court says, yes, you are appointed personal representative of dad's estate. And then we want to make sure that son is signing properly. He can't sign dad's name. Dad's passed away. He can't sign his name. He doesn't own the property. He's got to sign as personal representative of dad's estate. That's the seller in the contract. And I've got that listed later in the presentation, so you have an example of it. Let's go over what an estate administration looks like, because you're going to need specific paperwork from the probate court, and it's helpful to understand the timeline of an estate so you can see where you get that specific paperwork. Probate is a 3-step process. Number 1, we've got to identify, gather, and value the assets of the estate. That goes back to the question we asked on the first slide. How is the property titled? If it's titled in an individual's individual name and there's no beneficiary listed, meaning it's not an enhanced life estate deed or a life estate deed, that's going to be a probate asset. So we let the court know what all the assets of the estate are. We wait the time period it takes for the judge to review the paperwork. Most counties only have 1 probate judge, so it takes some time for us to reach the top of that judge's stack. And that's something that is kind of a reoccurring theme. Whenever we need to ask the court for something, we need to buffer extra time in, because it's going to take a couple of weeks for the judge to review our request and then grant it or ask for additional information. So nothing that involves the probate court is instant. So if we need paperwork to get to a closing date, we need to have as much lead time as we possibly can to get that paperwork from the court, especially if we need certified copies of documents so that we can record them in the public record. Now it's a 2-step process. We've got to ask the judge for that paperwork. The judge grants it. Then we've got to ask the clerk office to issue us certified copies. That's a separate waiting time, and that also takes a couple of weeks. So it can be really, really frustrating when we need to get paperwork from the court, unless everyone already understands that that's not something I can just call up the judge today and say, hey, I need these letters of administration so we can sell this house, and they're going to get it to me that same day. They just can't do that. They won't do that. So step 1 is important because this is where we get the estate opened and we have letters of administration issued. Once the personal representative has those letters of administration, you can list a house for sale. So the house can be listed for sale. The house can enter into a contract to sell the piece of property. The personal representative is going to sign it as personal representative of the estate. but we can't close on the property yet because we still have more to do in the probate process. And a lot of that has to do with step 2, paying creditors. So in Florida, creditors have 2 years to ask to be paid. That's a very long time. The good news about probate is we don't have to wait that 2-year period. We can reduce that 2 years to a 3-month time period. But that means that we've got approximately 90 days where we are waiting to see if the creditors are going to show up. Why is this important to you to sell property? Because if the title company determines that in order to close on that property, they need an order determining homestead, sometimes they won't close without that order determining homestead, sometimes they will, just depends on the title company. We cannot get that order determining homestead until we are outside of the creditor claims period. So we need to get a title commitment as soon as possible. The quicker we can get that title commitment, the quicker we can review it to see what the title company is going to need from the probate court. And if one of the things that they need is the order determining homestead, we cannot close on that property until we are outside the 3-month creditor claims period. So it becomes really important for you as the realtor and advocate for your client to understand where they are in this probate process, right? Because if we're just at the very beginning stages, we're not going to be able to close on that property for at least 3 months. Now, that's kind of the extreme situation because not all title companies are going to require the order determining homestead prior to closing. But if they do, we cannot get it any earlier than at the end of step 2. And then finally, step 3 is to distribute the assets to the beneficiaries. The good news is we do not have to wait until step 3 to sell property that's in an estate. We can sell it earlier than that. But to determine when we can sell it, we go back to the very first question that I asked. Is there a will or is there no will? The difference is if there's a will, the will probably has a power of sale in it. What that means, the will probably says my personal representative can sell property without authorization from the court. That saves us a step. If the will gives the personal representative the power to sell pieces of property, we don't have to ask the court for permission to sell the house. All we have to do is make sure that we're satisfying everything in the title commitment in order to clear title. If there's no will, there's obviously no power to direct sale because there's no written instructions whatsoever. So now, anytime we need to sell a piece of property in an estate, we have to get a contract for that piece of property and we have to petition the court. We have to ask them for permission to sell the property. This is an additional step that we have to take. And if you remember my waiting times, that means it's going to take an additional couple of weeks at a minimum before we even get authorization to sell that piece of property. So we need to factor that in to our closing time. Okay, so I told you earlier that I was going to give you an example of how the personal representative needs to sign a contract. They don't want to sign in their individual name. They need to sign their name as personal representative of the estate. That's really, really important whenever you have a contract for sale because we need to identify who the proper seller is, right? Personal representative is going to need those letters of administration. That's what they need at a minimum. I do not recommend listing property for sale until we have those letters of administration. Not because they can't do it, but because I know that's just the first in many steps that we're going to need to overcome and accomplish before we can get them to a closing date. So I prefer to have those letters of administration in hand when we list the property so that I know we're at least over the first hurdle. We at least have the first thing we need from the court. And then once we get that title commitment, we can review it so that we can see what else the court is going to require to sell that piece of property. So my tip for realtors, involve the estate attorney. Involve the estate attorney from day one. Send the title commitment as soon as you have it so that the attorney can review it. And plan on closings being at least 40 days out. They may need to be further than that if we need the order determining homestead. And again, that's going to be driven by the title commitment and the title company. Some of them require it, some of them don't. But if we do need it, know that we can't get it until we've passed and completed step 2, which is that 3-month creditor claims period. And all estates are different, so it just depends on the relationships between the beneficiaries of the estate, how cooperative is everyone, how quickly do they sign and get their paperwork back to the attorney. If we've got estates that have several beneficiaries and we're tracking down paperwork from them, that can delay timelines because I can't move on to the next step until I have authorization and all of the paperwork back from everyone that I need. So family dynamic drives a lot of timelines and issues with probate. It's why you might sell one piece of property in an estate and it goes really quickly, really smooth, no issues. And then you go to sell another piece of property and you expect it to be just as quick and just as easy, and it takes 5 times as long and there's a million issues that come up. Every single estate is different, and different pieces of property are going to have different hurdles that need to be overcome depending on what county they're in and depending on what is required from the title commitment. So on those contracts, I like to see the closing date pending court approval. That's helpful for the buyers to understand, hey, it's not just the seller's fault on if we can close or not close. It's not just in the seller's hands. This requires the court to be cooperative. So that's just a nice way to make sure that everyone's on the same page. We've got a third party involved here, and our closing date is going to be contingent on them being cooperative with our timeline. I like to see the title commitment as soon as you have it. I mean, the moment you get a signed contract and the title commitment, send it to the estate attorney. That's because I will review it and I will order everything that I need to order from the court as soon as I can. If the court needs me to petition the court for something, if the title commitment requires something, I can get on preparing that paperwork so that we're not waiting for an extended time period. The closings where I get the title commitment very quickly tend to run a lot smoother versus the ones that it's a week before closing and now all of a sudden I'm getting emails saying, hey, are we all set to close next week? And then I finally get the title commitment and I review it and they need 3 pieces of certified copies from the court. I'm never going to be able to get those certified copies from the court within a week because they just don't process the paperwork that quickly. And that can really hold up closing. So involve the attorney's office as soon as you know who they are. Keep them on all of your emails and communications. I promise it's not going to annoy them. They would prefer to be kept in the loop on what's going on with closings because we want that property to close as quickly as it can. We don't want it to hold up anything on the estate side. So the attorney is your friend. Utilize them. They will help you through this process. Again, I know I've said it a bunch. It's because it is the #1 factor for what determines whether a closing is going to go smoothly or if there are going to be hiccups. I need that title commitment as soon as possible because they are going to need paperwork from the probate court, and I can't force the probate court to issue it any quicker than they want to. Oftentimes we need certified copies of documents to be recorded. That only comes from the court. If there's a lot of beneficiaries or if they're kind of fighting a little bit, the court may not just give us what we want. They may require a hearing on the matter before they approve a sale. That's an additional layer of time, right? We've got to notice all of the beneficiaries. We've got to coordinate hearing dates and times with the judge. And then we've got to get on the judge's calendar to have a hearing. That could be a couple of weeks. That could be a month or more before we're able to get on the judge's calendar. So everything takes time. We just need to be as prepared as possible, and we need to set the expectation that the court may throw a wrench into our closing date, and we just have to be flexible about it and be able to move that closing date if the court requires it. If you have someone that is getting paid from the proceeds of the property, you can put the attorney's fees and the court costs, the estate costs on the settlement statement. Send that out to the attorneys for review so they can make sure if they want costs included, that you can get it included in time. This will help you be a shining star in the attorney's eyes because they really, really appreciate being sent these documents early so that if there's any revisions that we need to make, we can make them, and they're going to refer you more business if you are helpful and involve them in the process, because they're really going to appreciate working with you because they know how difficult it can be to sell property in an estate. And if you understand the process and you're willing to work with them, they're really going to appreciate that. And they may send lots of referrals your way because it's very, very common that we have estates with personal representatives that live far away and they don't know anyone local looking to sell pieces of property for them. So typically they will come to their estate attorney for referrals for title companies and realtors and professionals that are local that can help guide them through the process. And attorneys are looking to work with realtors that understand what they have to do on their side. So if you as a realtor can help your client understand a realistic timeline for what it takes to sell a piece of property in a probate, that is not going to go unnoticed by the attorney's office. All right, so we talked about selling property if there's a will versus no will. There's also a difference on whether it's homestead property or non-homestead property. And so we spoke a little bit about this earlier with that order determining homestead, but there's another difference. Once we have the order determining homestead from the court, that acts as a deed from the probate property, transferring title into the names of the beneficiaries. So if you are selling homestead property, you need to talk to your client, who will likely be the personal representative, and you need to see who the beneficiaries of the estate are, because they may need to sign the closing paperwork and the deed in addition to the personal representative. And that's because once that order determining homestead is entered by the probate court, it's no longer in the personal representative's hands. It's in all of the beneficiaries' names. And so they are now the owners of the house. They will need to sign the closing paperwork. Know this in advance so that you can coordinate potentially mail away closings if the beneficiaries are scattered throughout the United States or the world. It just is helpful to know this as early as possible so that we're not scrambling 3 days before closing when the title company says, hey, we're going to need all heirs to join in this deed. And now we've got to coordinate a signing with 5 people versus 1 person. So heads up, that is very, very typical. And if that title company needs that order determining homestead, can't get it any earlier than the end of that 3-month creditor claims period. It is potentially possible that if we have a lot of beneficiaries or if we have extenuating circumstances, that we can file a document with the court asking the court to allow the personal representative to take possession of homestead property. If the court allows the personal representative to take possession of the homestead property, now only the personal representative needs to sign the closing paperwork. But that is something that needs to be done early prior to the order determining homestead being entered. So it would need to be done during the creditor claims period or earlier. So it's not an option all the time, but it is an option sometimes if we have extenuating circumstances that might lead to the house getting damaged or something happening with the property, or we have several beneficiaries that are not going to all be able to sign. If that is an option you want to pursue, talk to the estate attorney as soon as possible so that they can decide if it's going to be appropriate in that circumstance, and they can prepare the paperwork to submit to the probate court as soon as possible. Non-homestead property, it can be sold at any time, okay? If it's sold during the creditor claims period, we are going to have to hold the proceeds until we are out of that 3-month time period. That's because if there are creditors in the estate, those home proceeds are available assets to satisfy payment of those creditors. But that's okay. That shouldn't hold up closing in any way. It just means that the funds from the proceeds of the sale need to be issued to the estate. So you may need to talk to the attorney so that they can give you their estate escrow account information so they can hold it until they're out of that creditor claims period. And then the attorney's office will be responsible for distributing the proceeds to the beneficiaries. Again, if there's not a will, we need to ask the court for permission to sell the property. So we cannot pick a closing date before we have that court approval. All right. My main takeaway here is probate property, selling property in probate takes longer than it does selling property when you have the person that owns the property alive. Because we are beholden to not only the title company, but also the probate court, we have to ask them for permission for almost everything. Permission to sell the property, permission to get documents from the estate that we need to sell the property. So working with the attorney can help give you a realistic timeline to pass along to the buyer and to your client, the seller. It really should be taken as a team approach. When it's a team approach, it tends to run a lot smoother. And don't wait too long before you get the attorney involved. Get them involved as soon as possible so that they can get the ball rolling on whatever they need to get from the court. All right, any questions?
Thank you so much, Michelle. I started jotting questions down because I didn't want to keep interrupting you, so my apologies. I have a few here.
Sure.
But first of all, I just wanted to say thank you so much for taking the time to do this. It was very informative, and I look forward to working closely with you or with other attorneys that we might have. With the states. What I'm wondering is if I have a client come to me and maybe their relative just didn't have anything, they didn't have they die intestate, can I refer them directly to Hoyt and Bryan or to you then to get, and then we work in partnership from there?
Yep.
Okay.
Yes, absolutely. If they don't have an estate open, then they will need to get an estate open. So yes, we are absolutely happy to help them. We do offer complimentary 15-minute calls just to see if we're able to help them, go over the process, talk to them about timelines and fees, because sometimes they're able to do it themselves depending on when their loved one passed away and the value of the property. But most of the time they're going to require an attorney to go through a formal administration. And yes, we are happy to help any and all of those clients.
Okay, cool. And then you had mentioned, I guess, that there are times when the court will require certain certified copies of documents. Are there some that are, can you give me some examples of some of those documents that they may require? Or is it kind of all over the place?
Yeah, so some of the general ones, if there's a will, they're going to require a certified copy, typically, of the petition for administration. So the document that we use to open up the probate court. They're going to require a certified copy of the order admitting the will and appointing the personal representative, because we need something to show that the person signing the closing paperwork has authority, right? And they're going to need certified copies potentially of the letters of administration, of the order authorizing sale, if we have to ask the court for authorization, and then of the homestead determination if it's homestead property.
Okay, cool. And then, obviously we're beholden to the court. I mean, I definitely got that, for all of this. Are you seeing are there backups maybe certain times of the year, or COVID related backups? Are you seeing any kind of change, or is there kind of a standard amount of time typically?
Yeah, there are some COVID related backups that may kind of shake themselves out hopefully soon. But typically, anytime we send a request to the court, whether it's a request to the clerk's office for certified copies that have already been issued by the court, typically take about 10 days. So, a week and a half to 2 weeks. So that takes a little bit of time. And anything that we send to court for court approval is going to depend on the county. But a general timeline is 2 to 4 weeks. Can be sooner, but some of those counties are really running in the 3 to 4 week range. And I know that can be really frustrating, but there's just that one judge, and the one judge has an increased volume of estates, whether that's because of COVID or whatnot, but they're busy.
Yeah,